Hi, I'm Kevin Michalowski, editor of Concealed Carry Magazine. In this edition of Into the Fray, let's talk a little bit about what you say or don't say to the dispatcher. Okay, so you've been involved in a deadly force incident and you have wisely called 911 to get help rolling your direction. First thing I want you to remember is that the dispatcher is not the police. The dispatcher has no legal authority and cannot tell you what to do. Now, don't let anyone think I'm disparaging dispatchers. Dispatchers have helped me in lots of occasions. I really like dispatchers. They send help your way. They do lots of good things. But you have to think about yourself when you're on the phone with the dispatcher after a self-defense incident. Remember that everything you say to the dispatcher, everything you say while you're on the phone with 911 is being recorded. And that information may be used against you. In fact, it probably will be used against you, especially if you're really emotional and you're providing what the prosecutor will call an excited utterance. People tend to think that those are automatically the truth because you're excited and you're not thinking about telling a lie. Well, in many of those cases, your excited utterance is just that you haven't got your brain around what's happened yet. You haven't figured it all out and you're still nervous. So slow down, don't say much to the dispatcher, and remember, the dispatcher is not going to be giving you orders. I know we all heard about what happened in the Trayvon Martin case where the dispatcher told George Zimmerman, and I quote, "You don't need to do that." And everybody grabbed that. All of the people who were against George Zimmerman and thought he should be tried for murder grabbed onto that and said, the dispatcher told him that he shouldn't be following that guy. Well, they showed it right in Florida law. The dispatcher has no legal authority. The dispatcher can't tell you what to do. Typically, a dispatcher will probably give you good advice, but not always. And again, that's not legal advice. That has no authority. You don't have to follow those instructions. Do what you think is right. Do what you've been trained to do and be ready to articulate your actions. Tell the police officers everything that you did, with your attorney present, of course, when it comes time to make a statement. Don't rush to make a statement. Don't be saying a lot to the dispatcher. Now, I'm not an Apple guy, but I've been told that some of the new iPhones won't hang up if you call 911. The iPhone won't allow you to hang up. It waits until the dispatcher hangs up and then it stops the call. Either way, if you call 911 and you're on the line and you got the open line, if you don't want to talk, stop answering questions. The dispatcher will be trying to get as much information as possible, and that's just to help responding officers and EMS and other people who are on the way. But remember, anything you say will be recorded and can be used against you. That's just like you're making a statement. That's evidence. So, when you're on the phone with the dispatcher, tell them you've been attacked, tell them that you need help, give them the location, and then be quiet. If there's anything else that's really, really important, you decide for yourself whether or not you want to say that. And remember, the dispatcher will keep asking you questions and keep prodding you to find out what's going on in order to give more information to the responding officers. And again, anything you say is going to be recorded. You're going to hear it later in court. You're going to hear it later while you're giving your statement. So just stop and think. You don't have to make any statements without your attorney present. I'm Kevin Michalowski, editor of Concealed Carry Magazine. This has been Into the Fray. If you like these videos, click like and share these with all your friends. And please subscribe to our page. We'll give you more great information every week.